And welcome to this fifth CUP webinar in the comparative law series, where we will today be discussing interim measures over the next hour and a half. We have a very impressive lineup of esteemed panelists for you today, which I have the privilege of moderating. My name is, first of all, Jacob Jorgensen. I'm a Danish lawyer. I'm specialized in construction law, and I've been a fellow of the Chartered Institute of Arbitrators, that's me, since 2016. I normally deal with construction disputes, but I'm also the co-author and editor of the book Finding, Freezing and Attaching Assets, which deals with especially interim measures, where we analyzed some years ago. This is a Kluwer arbitration, a Kluwer publication, where we analyzed some 10 jurisdictions and the way interim measures are dealt with. So that's my background for moderating this panel. And to go to the speakers, first of all, we have Dr. Alexandre Malin, who is a French lawyer. He's a partner of Belot Malin Associés in Paris. He holds a doctorate degree in private international law. He's a lecturer in international arbitration and civil procedure at the Paris 12th University. He works in litigation and arbitration, and he will tell us about his experiences with interim measures under French law. Secondly, we have Carlos González Bueno, who is a Spanish lawyer. He's the founding partner of González Bueno SLP in Madrid. He's the co-author and editor of the commentated Spanish Arbitration Act, and he's worked in various fields of international arbitration for more than 30 years. He will be sharing his views and experiences with interim measures under Spanish law. Next, we have Patricia Sangalli, who is an Italian lawyer also admitted to the Madrid bar. She's the founding partner of SNG and Partners in Milan, in Italy. She's an expert in M&A disputes and construction disputes, and has worked under all of the major arbitration institutions. In addition to English, Spanish, and Italian, she also speaks and is fluent in Polish as a working language. She will share her views of how interim measures are dealt with under Italian law. Next, we have Professor Dr. Hartmut Hamann. He's the founder of Hamann Rechtsanwälte in Stuttgart. He's a former longtime partner of CMS Hasche Siege and a former lecturer at the Freie University in Berlin and also at the Technical University in Chemnitz. He's an expert in construction disputes, and he'll be telling us about his views on interim measures under German law. Finally, we have one of my Scandinavian colleagues, Knut Jacob Knudsen from Norway. He is barred both in Norway and in England and Wales. He's a partner at Simonsen, Vogt and Wiig, where he's heading the international arbitration department of that firm. He's a specialist in construction and M&A disputes, among others. He's a member of the board of the Stockholm Chamber of Commerce Arbitration Institution, and he will be telling us about Norwegian perspectives. So that's the lineup. I understand that most of the speakers will be telling some anecdotes about interim measures. So that will basically take us to the bottom of this hour, and then we have half an hour for questions. So if you want to start, Alexandre, the floor is yours.
Thank you very much, Jacob. Can you hear me properly? Yes?
Yes.
Thank you very much. So, yes, I will explain briefly the French background, the French legal background on interim measures and arbitration. And then, as suggested by Jacob, I will tell you about an experience I have with an interim injunction that we will be able to discuss later on, if you would like. So the French background is comes from a decree of 2011, and which defines clearly a balance between the arbitrators and the judge in two phases. basically Article 1449 of the Code de Procédure Civile, which is the procedural civil code, states that the judge has jurisdiction to decide on interim measures until the moment the arbitrators are appointed. So until not appointed, but until the moment the arbitral tribunal is constituted, which is a bit different. So the judge has full powers to decide on interim measures until that moment. And then when the tribunal is constituted, the tribunal has jurisdiction to decide on interim measures based on Article 1468 of the same code. So, and Article 1468 basically says that the arbitrators can render interim injunctions, and those injunctions can be the arbitrator can decide on penalties to force one of the parties to follow the injunctions. So the point, the limitation of the powers of the arbitrator is clearly stated in the same article, which states that the arbitrators can render interim injunctions to the exclusion of provisional seizures. That means that we have a specific judge in France for ordering seizures and provisional seizures, and the arbitrators do not have the power to order such seizures. So that means that basically the party who is willing to make an attachment on assets will have to go in front of the judge, even if there is a pending arbitration going on. And we have an article which is 1469, which completes this set of articles, which is interesting because it concerns third parties. And this article basically says that one party to an arbitration is entitled to ask the arbitrator to be authorized to go in front of the judge, to seek assistance of the judge in order to obtain from the judge an order towards a third party to the arbitration, in order to for the production of documents. So in other words, a third party who is not a party to the arbitration will be ordered by a judge, a national judge, the production of documents that might be useful in the course of the arbitration from one of the parties. So that's a very interesting asset. And to complete that, we have something which is interesting in my view in French law. And I recently discussed with US colleagues, US firm with which I usually work. And they do not have that in the US. And they are very interested by this tool, which is Article 145, which allows one party in an ex parte proceeding or contradictory proceeding to ask the national judge the production of documents or any investigation measures that would be necessary for a future case, either before courts or even before in front of an arbitrator. So if you have an arbitration clause in a contract, for instance, you don't have the documents that are necessary in support of your case, you would be able to use this Article 145 to ask the judge to order the production of that document or to order any investigative measure in order to get that document or that piece of evidence in order for a future claim in front of the arbitrators or the judge. So that's an interesting tool that we have in France. To close on that, very brief experience, which is quite different from the 3 or 4 articles that I quoted. But I think it's an interesting case because 2 years ago we were asked by US colleague to go in front of the judge in France to seek an order against a third party to the arbitration because that third party was using material and information from an ongoing arbitration. And we were looking for an order to injunct that third party to stop disclosing confidential information from the arbitration. And we basically obtained that order. The first round where we sought an ex parte order from the judge, and this order injuncted the third party to stop disclosing information pertaining to the arbitration until a contradictory debate would take place with that third party on the opportunity to have a final judgment ordering the same third party to stop disclosing confidential information from the arbitration. And the interesting part of that is that the debates in front of the judge on the confidentiality of the arbitration themselves were confidential, so behind closed doors. And that's quite uncommon in French law to have secret debates in front of a judge for a civil or commercial matter. So that's my anecdote on injunctive reliefs in parallel arbitration proceedings.
Very interesting. Thank you so much for that. Next on the floor is Carlos Gonzalez. Buenos. What is yours?
Thank you very much. I will give a very quick overview of the Spanish legal frame. The law, our law is from 2003. It was reviewed in 2011, and it follows the model law. So don't expect very different things from those you are already accustomed to. We have a dual system of interim measures where you can ask them to the arbitrators and to the national courts. There was an important exception, which was Italy until recently, but I learned that now it has also this dual system, so I can't think of any other exception at this moment. So the fact that you can ask for this, claim this measures to the judges and to the arbitrators doesn't mean that they work in the same way. Obviously, the arbitrators will always need to rely on the judges to enforce, or rather the parties will need to rely on the judges to enforce the measures if they have been granted. But this is not the only point in which they would differ. If in Spain, judges are, I wouldn't say they are reluctant to grant these measures, but they are pretty conservative. You need to have a very strong case. In case of doubt, or not only in case of doubt, if they don't see a very clear case in favor of the applicant, they will tend to refuse them, to deny them. So I would, as a counsel, not as an arbitrator now, as a counsel, I would suggest that they go to the arbitrators and ask them in the first case. Only if there's a strong or there's a good reason for going to the judges, then in this case, I would recommend that they do so. Arbitrators are obviously much more flexible. The judges will need to follow this Civil Procedure Act, which doesn't foresee many particularities for the measures adopted in the frame of a arbitration and in a judicial case. They're almost the same, so it's pretty rigid, and the capacity, the margin of maneuver the judge will have to adapt to a very specific case in an arbitration isn't wide at all. He can adapt it as he would, or she would adapt it to a specific process before the courts. But the rules are the rules, they're imperative rules, and the judge needs to follow them. On the contrary, the arbitrator has a huge margin of maneuver. He can adapt the measures to the very specific circumstances of each case. And well, another difference is that he will be much quicker. The party autonomy before the arbitrators is very broad. You can even waiver the measures before the arbitration. This is specifically foreseen by the Spanish Arbitration Act, and this would not be allowed before the courts. You can't waiver the courts ex ante. Because we consider this to be a right of the effective judicial protection, and this has a constitutional range, and it is constitutional in nature. So once you can ask them, you may ask them or not, you're not forced to it, but before the arbitration starts, you can't waiver them as a matter of principle. The competent part when it's the court is the courts of first instance. They have a big load of work, a big caseload, and this it won't take as a main case before the courts, but it can take months. Whereas before the arbitrators, it can be a matter of weeks, and before an emergency arbitrator, it can be a matter of a little more than 1 week, maybe 7 to 10 days. You can have an order or an award. So again, one reason to direct our claims directly to the arbitrators. And there's one thing, in another case, the arbitrator or the judge can order them ex officio. Under Spanish law, it's very obvious that the party needs to ask for these measures. The only thing that the court or the arbitrator can do without an extra petita is to change them and for other measures that adapt better to the case, or are less burdensome for the opposing party. In the ex parte interim measures, this is important because in many jurisdictions, the arbitrator will be allowed to order them. In Spain, this is not clear at all. The judge can do it, the law foresees it, but we see this as something very exceptional. In a way, it's an exception to a constitutional right of the parties to be heard. And so if the law says so, then the judge can do it. But the Spanish Arbitration Act doesn't say so. So in the absence of an express provision, most of the scholars, of the commentators, think the arbitrator shouldn't allow it. And an arbitrator who's more or less prudent in Spain, in case of doubt, would not grant it. And one of the most important arbitration courts in Madrid, which is the Madrid Court of Arbitration, in its rules expressly foresees that this is not allowed. The time of the arbitration, obviously, as in every jurisdiction, it can be done during the arbitration before the arbitrator, so before the arbitration before the emergency arbitrator. Our law doesn't foresee this figure, but all the rules of the institutions, or maybe all the rules of the relevant arbitration institutions in Spain do so, and it works perfectly well. There's one thing in a specific point in Spain, which is for us in our culture, we don't only have the periculum in mora, but also the fumus bonis iuri. And this is important because the arbitrator won't just need, or the judge, it won't just need to consider if the measures will be able to be adopted after the final award is drafted, or if they will be imperiled by the lapse of time. But it will also need to consider the fumus bonis iuri, if the case is solid on its merits. And that is interesting because I had a case in which I was asked as an emergency arbitrator to grant some emergency relief. And I thought at that point that the periculum in mora didn't exist. It could wait, not until the final award, but I thought it could wait until the main tribunal was constituted, and they should be the ones, this was a tribunal, it wasn't a sole arbitrator. I thought it would be much wiser if they, with more calm, decided on this matter, and not me as an emergency arbitrator. And I thought it was a matter of weeks, and there wasn't such an urgency. But at the same time, I was forced by the Spanish law to pronounce myself on the fumus bonis iuris, and this was tricky because I thought the party who asked the measures, which I finally declined, dismissed, has had a strong case on the merits, and it was my obligation to examine it and to state, in my opinion, it was. So in a way, one party had a sweet loss and the other a Pyrrhic win, because they found an award rendered by an emergency arbitrator, but something that obviously the final tribunal would consider, because the parties would bring it to its attention, in which I preliminarily examined, so that the case had a rather solid base. So this is something obviously one of the parties wouldn't have wanted, and but it was my obligation to examine it and to give my opinion on it. The decisions obviously can be reviewed by the final tribunal if they were rendered by the emergency arbitrator, and this is often the case. But it's also often the case that the tribunal reviews its own decisions, so the circumstances can change, and the tribunal can review them. But one thing I would, with another case I had, and with this I would like to end this first intervention, is that in Spain, I mentioned it before, the courts are quite reluctant to grant interim relief. I wouldn't say the arbitrators are. I think the arbitrators are more neutral. If they see grounds for granting them, they will, and if not, they won't. They aren't as conservative as judges. But I do think you need to have a rather clear case. The arbitrator needs some energy, some conviction that there's a reason for this interim relief. Otherwise, he or she would think, okay, let's not rush, let's not hurry, let's take some more time, let's produce the documents, let's examine the witnesses, let's not rush. Justice needs some time. And the risk is that if you ask for measures and these measures are finally not granted, I think this can have a negative impact. And it's not getting off on the right foot. I think a 52% chances of winning them is not enough. You should have a strong case in which it can help you. If you have an interim award or an interim order and you start off the main arbitration case with this, that will help you. But if you started with measures which are finally refused, you're not starting off with the right foot. You're starting off with the wrong foot. You will need to justify why with more evidence or with more witnesses, documents, with a deeper understanding of the case. The judge, the finding of that tribunal, of that arbitral tribunal would be different. So my advice would be, if you have a strong case, if you need the measures, obviously ask for them. If it's only a so-so, yes, a 52%, I would give it a second or even a third thought. Thank you very much.
Thank you very much, Carlos. So next speaker is Patricia. Over to you.
Thank you, Jacob, and thank you for the kind invitation and introduction. As far as it concerns Italy, as Carlos mentioned, we had a reform, and this reform is very recent because it started in 2022, and it was to make Italy more arbitration friendly. So the recent reform has finally put an end to the historical prohibition for Italian seated sole arbitrators and arbitral tribunals to grant interim measures. And there is another implication which is important, of course, the possibility to enforce in Italy provisional measures rendered by arbitral tribunals seated abroad. So I will give you a short overview of the reform. As anticipated, is to empower arbitrators to grant interim provisional measures only if the parties expressly provide that in the arbitration clause, or in case in written form before the commencement of the arbitration proceedings. The parties can grant the arbitrators with the power to issue interim measures also implicitly by referring to the rules of an arbitration institution, which provide these powers. And I will give you some inputs also on that. So in each of the cases, the jurisdiction of arbitrators to issue interim measures is exclusive. Given the high number of Italian parties involved in international arbitration proceedings, in 2020, I can tell you that together with France, Italy was the fourth most frequent nationality among parties to ICC arbitrations after United States, Brazil, and Spain. And so the frequent recourse to interim measures in cross-border disputes and the issue of the enforceability in Italy of provisional measures rendered by foreign arbitrary tribunals has always been of key importance. So the recent reform is very important because Italy was, let's say, stopped in this way in the proceedings to issue interim measures. So Article 818 ter of the Italian of the Italian Code of Civil Procedure expressly set for a mechanism to give effect in Italy to these interim measures. And the other consequence of this Cartabia reform, because the name is Cartabia, and consists in having equated domestic protective measures with foreign ones. So the important thing is that the foreign measures are also enforceable in Italy without being subject to a previous procedure of control by the Italian judge, judgment of exequatur. And this is, of course, a remarkable fact. Generally speaking, states that agree to enforce provisional measures issued in foreign arbitration do not renounce submitting the measure to prior scrutiny by the courts. So another important thing is that well, such measures may the arbitrator reform could not issue this protective measure, and what is the consequence right now? That such measure may subsequently be modified or revoked by the arbitrators once the arbitral proceeding have been instituted and they have become capable of acting, provided that the power to take precautionary measures has been expressly conferred. To give you another important point is the enforcement. The enforcement of interim measures granted by arbitrators is governed by and carried out under the control of the court in whose district the seat of arbitration is located. Or if the arbitration is not seated in Italy, the court of the place where the provisional measure is to be implemented. For judicial interim measures, the same judge who issued the order oversees its enforcement. For arbitral interim measures issued by arbitral tribunals seated in Italy, enforcement procedures are overseen by the court of the seat of arbitration, while for foreign arbitral interim measures, the court overseeing enforcement is the one of the place where the measure is to be implemented. So this is very important. And well, another issue with the reform is also well, the reform of the arbitration rules of the Milan Chamber of Arbitration, which entered into force on March 2nd, 2023. So this is all very recent, and it includes a new provision on interim or provisional measure in compliance with the Cartabia reform of 2022, we have this Article 26 of the Rules of CAM, which establishes that unless otherwise
Can you hear us, Patricia? You froze. Leave and then log back on because you are frozen. Just opportunity to log back on. Meanwhile, we can take perhaps one of the many questions that's coming in. What are the challenges to arbitrators' powers to grant interim injunctions? So perhaps someone would fill in the waiting time by addressing that. Anybody?
Is it the challenges to the powers or to the decisions?
To the powers, I think that's the.
Because that's much broader than the challenging a decision on measures.
What are the challenges to the arbitrator's powers to grant an interim injunction? That's the question from the floor here.
If I may, I think one of the challenges of the powers of the arbitrators is the enforcement of the injunction of the arbitrator, as suggested by Patrizia. I understand that under Italian law, you basically don't need to have an exequatur or enforcement order from the judge, which I find it quite interesting, and maybe Patrizia, when she comes back, she can comment on that. But that seems to me a bit unfamiliar to French law, because in France you have to get an enforcement order on any of the awards rendered by the arbitrators, including interim orders or interim injunctions. So, and that may, to some extent, that may sometimes take some time, that because it can also be challenged. So I see that as one of the main concerns. But I see that Patrizia is basically coming back.
Sorry about that.
It's back. There we go. Excellent.
Okay, I am here. So I was telling you about the Article 26 of the rules of the CAM rules. So it establishes that unless otherwise agreed by the parties, the arbitral tribunal can grant urgent or provisional measures or of protection, also of anticipatory nature, that are not barred by mandatory provisions applicable to the proceedings. And upon the request of the applicant party, the arbitral tribunal may grant the order even without notice to the other party, if such notice may seriously harm the applicant interest. So the arbitral tribunal may order the party requesting an interim measure to provide appropriate security for costs as a condition to issue the measure, and any request for interim measures made by a party to a judicial authority does not imply any waiver of the effects of the arbitration agreement of the request for arbitration. So as you can see, there is a new balance between the state court and the arbitration court. If the arbitration clause provides the competence of arbitrators to issue interim measures, the parties are bound by the provision and they cannot submit their request for interim measures to Italian court. But the competence of the Italian court is not completely barred. First, according to the new Article 818, the parties have to submit the request of interim measure before the Italian courts when the sole arbitrator hasn't accepted its appointment yet, or the arbitral tribunal has not been constituted yet. And in those cases, the parties cannot wait the appointment or the constitution of the arbitral tribunal to obtain the interim measure. Considering the reason of urgency, the parties shall file the request with the competent Italian court. And so in this context, with the now amended Article 818 of the Italian Code of Civil Procedure, we have this provision that prior to the acceptance of the sole arbitrator or the constitution of the arbitral tribunal, the application for provisional measures shall be brought before the ordinary court. Italian courts therefore have exclusive jurisdiction to grant provisional measures before the arbitral tribunal is constituted. On the one hand, it may be argued that the provision prohibits emergency arbitrators altogether. From an Italian law perspective, parties would therefore be precluded from conferring upon emergency arbitrators the power to grant provisional measures, as well as from enforcing their orders. And this would affect the arbitrations seated in Italy, where the prohibition would rather take effect as lex fori when attempting to enforce the emergency arbitrators orders in Italy. But I would like to give you also another information. If you look to Article 26 of the new CAM rules, the arbitral tribunal has the power to issue all the interim, urgent, and provisional measures, as I mentioned, also of anticipatory content that are not forbidden by mandatory rules applicable to the proceedings. And in addition, if the arbitral tribunal, as we saw, is not yet constituted, the parties may address the request for interim measure to the state court. But there is another article with the rules of the Milan Arbitration Chamber, where Article 44, which indicate the emergency arbitrator as the one with the possibility to issue this kind of orders. So there is a diachronic concurrent jurisdiction. The state court has jurisdiction before the constitution of the arbitral tribunal, the latter from the moment of its constitution, and a synchronic concurrent jurisdiction. Both the state court and the CAM emergency arbitrator have jurisdiction before the constitution of the arbitral tribunal that will hear the merits. So this is an interesting point, since the new CAM arbitration rules apply to arbitral proceedings commenced on or after 1st March 2023. No relevance is given to the time of the conclusion of the arbitration agreement concerning the power to issue interim measure after or before the constitution of the arbitral tribunal. So the reference in the arbitration clause to the arbitration rules must be considered as a mobile reference according to Article 832 of the Italian Code of Civil Procedure. This is because the choice for administered arbitration is based on the parties' trust in the arbitral institution and cannot be resolved in the choice of arbitration rules enforced at the date of the arbitration clause. So these are the points where we can talk about that, of course, during the discussion, but these are the important points I wanted to give you. And I will just mention something that we can discuss after the other interventions, which is the ineffectiveness of the protective measure. So this point is important. The rule attributes to the judge who issued the protective measure the competence to declare its ineffectiveness. And here is the central problem is linked to the concrete identification of the subject, because there are two problematic points. First is the problem of who should declare the ineffectiveness when the measure was issued by the judge before the arbitrator's appointment. And secondly, it must always be considered that there may not be an arbitrator at the appropriate time. There is always a judge, and we do not have always an arbitrator. So I will leave this for the discussion maybe after the other interventions. Thank you very much.
Thank you very much, Patricia. Very interesting insight. I'll hand you over to the next speaker, who is Professor Dr. Hartmut Hartmann.
Thank you, Jacob. Let me briefly give an overview about the legal framework for interim measures under German law with regard to arbitration. But the starting point is that the German Code of Civil Procedure explicitly allows for interim measures by state courts at any time of arbitral proceedings. So the wording is, it is not incompatible with an arbitration agreement for a court to order before or after arbitral proceedings have commenced, and upon request by a party, an interim measure or measure of protection concerning the subject matter of the dispute submitted to arbitration. And this is applicable for arbitration proceedings when the seat of arbitration is in Germany, as well as when the seat is in a foreign country. So under German law, you can always ask for interim measures by a state court. And in many cases, this is the better option, because it can be quite fast. I mean, there's no guarantee. It depends from the judge and from the court, but it can come within days. So German courts they are not always very quick, but they can be. So you may have a court order within a short period of time, not always within days, but it may happen within, let's say, a couple of weeks at least. So that is the idea behind interim measures in Germany. So yes, they are possible even when you have ongoing arbitration proceedings before or afterwards. But of course, when you ask the state court for an interim measure, you have to meet the requirements also set out by the German Code of Civil Procedure. That means a bit like Carlos, you said, you need a strong case. You have to make sure that you have, you have to find a competent court. You need a legally justified claim, and you have to prove, at least prima facie, that you have such a claim. And you have to convince the court that you urgently need an interim measure. And once again, it's up to you to prove, at least prima facie. So you need reasonable arguments and reasonable documents to convince the court to get the interim measures. So this is briefly summarize the way you get an interim measure by a German state court. German law also allows arbitral tribunals to grant interim measures. That's at section 1042, the German Code of Civil Procedure. By the way, available in English online. If you go to the website of the German Ministry of Justice, you will find an English version of the German Code of Civil Procedure. So the wording there is the parties are to be accorded. No, this is not the correct wording. So of course you can also ask, no, let me put it this way. Arbitral tribunals are allowed to grant interim measures. They are allowed to do so. But if you want to enforce them, you always have to ask a state court. So you need both. It's not enough to ask the arbitral tribunal. You can do so. They are allowed to do so under German procedural law, but it's up to the state court to take a decision to enforce the interim measure decided by the arbitral tribunal. So you always need two steps, which is a strong argument for asking for interim measures before the state courts, because there you don't need the two steps. And the major rules of arbitration, the DIS rules, the IS rules, the arbitration rules in Germany, they, of course, respect the legal framework. They allow for interim relief, Article 25. Unless the parties have agreed otherwise, the arbitral tribunal may, at the request of a party, order interim or conservatory measures. But even these arbitration rules clearly state the parties may request interim or conservative measures from any competent court at any time. So even the arbitration rules clearly state that you may go to the state courts. When reading the DIS arbitration rules, that seems to be broad. The arbitral tribunal may grant interim measures. The ICC rules are even more vague and broader. The arbitral tribunal may, at the request of a party, order any interim or conservative measure it deems appropriate. It seems to be very broad, but you should know when you have arbitration proceedings with the seat in Germany and with German arbitrators, these arbitrators in many cases tend to apply the same requirements, more or less the same requirements than state courts do. And I do so as well, and almost all colleagues doing arbitration tend to apply more or less the same requirements. So it's not easier to get an interim measure in Germany from an arbitration tribunal than it is before the state courts. So, for example, I usually ask the following requirements to be met. The request for interim measures must rest on a valid reason, which requires the requesting party to show that it is likely to suffer irreparable harm if the measures are not ordered, what we call in Germany Verfügungsanspruch. This is first requirement. Second one, the request for interim or conservative measures must be proportionate, considering all the circumstances, including the potential harm that is likely to result from the measures for the party against whom they are directed. Third requirement, the requesting party must show that the requested interim measures are needed urgently, and it must be a precise interim measure you are asking for. So, for example, under supply contract, if the supplier is not delivering the goods, it's not enough to say, please continue to deliver. No, you have to say which goods, which parts, and for which period of time. You have to be very precise. Next requirement, granting the interim measure will not amount to a prejudgment of the merits of the dispute. So no final decision before there is the real arbitration. There are some exceptions to that. There are some exceptions for that, especially under supply contracts, because you need the parts. So yes, there may be an interim measure forcing the supplier to deliver them, but only for a given period of time, and only for specific parts, and only if you can show that you urgently need them and that you will have severe damage if you don't get them in time. So it's not easy to get. It's not impossible, but it's not easy. On the merits, the request for interim measures must be justified on a prima facie basis. This requires the requesting party to show that there is a reasonable possibility that it will succeed on the merits of the claim, what we call Verfügungsgrund. The applicable standard of proof is a prima facie test. The tribunal need not to be satisfied that the conditions for granting interim measures are met beyond reasonable doubt. It is sufficient for the requesting party to demonstrate that the conditions for granting the measures are met with reasonable possibility. But that you have to show. You really have to convince the court. So I agree with you, Carlos. You need a well-documented case. If you don't have it, don't go for it, in my view. Unless you really need it, you have no other option. But if you have a weak case and you start by asking for an interim measure, it's a bad start. So what I can say to summarize, yes, under German law, you can ask state courts. You can also ask the arbitral tribunal, but in both cases in Germany, you need a strong case. You really have to convince the court that you have a good claim, a legally valid claim, and that you need the interim measures, the precise interim measures, urgently. This is a brief overview of how we do it in Germany. Thank you.
Thank you very much, Hartmut, for that very clear overview. The last speaker is Knut Jacob Knudsen, so I'll hand over to you, Knut, for a Norwegian view on interim measures.
Yes, thank you so much, Jacob. I thought that I would share with all of you a story about interim measures relating to the attendance of witnesses and one of my own cases. But before doing so, I've seen from the chat there's been a number of questions regarding the legal framework. So I'll just very briefly present that under Norwegian law, and by saying that it is very, very similar to what Harmut has just presented with regard to Germany. And in Norway, at least, the situation is that both the regular state courts and the arbitral tribunal can order interim measures. The tribunal can order measures that are considered necessary, and that is also the situation for the state courts, even though the requirements are a bit more spelled out in the Code of Civil Procedure than they are the Arbitration Act. Though the big difference between the measures ordered by a tribunal versus those ordered by a court is that only the orders made by the court can be enforced. So those are coercive measures, while the orders from the tribunals cannot be enforced. Now, just to go back a little bit back to my story, which I think can illustrate some of the practical aspects of interim measures, and hopefully provide some insight that you can find valuable. So I was counsel in a fairly large SCC arbitration, which was seated in Stockholm. It was a dispute between a Norwegian party, which we represented, and a Chinese shipyard, and it involved the construction of an offshore vessel. And one of the main issues in dispute was which party had design responsibility. And the situation was that we wanted to secure testimony from an independent third-party surveyor who was not a party to the arbitration. And this testimony was a key component in our case because the surveyor had been present at some pre-contractual meetings and had written minutes of these meetings and some emails also following the meetings. And based on the wording of these minutes and these emails, we were fairly confident that this testimony from the surveyor would favor our client. But since this, and also let me mention that since this third party was independent and had no interest in the outcome of the case, it was our opinion likely that the tribunal would place considerable emphasis on the surveyor's testimony. Now, the problem was that the surveyor, he didn't want to get involved in the dispute, and he lived in Norway while the seat of arbitration was, as I mentioned, in Sweden. He wanted to remain neutral and not take sides, and therefore he refused to testify. And we had a number of rounds of emails, we had Teams meetings trying to convince him to testify, but his opinion remained firm, and he even went to the step of hiring his own lawyer, which I found quite unusual, but that actually is actually what he did. And this reluctance, sort of resulted in a situation where we were, faced with how to proceed. Now, one alternative would, of course, be to give up and to continue the case without the surveyor's testimony, given his unwillingness to testify. But we felt that our chances of prevailing would increase substantially with witness testimony from the surveyor. And this then led us to ask which interim measures were we then in a position to ask for. And in our situation, the tribunal was essentially powerless because in this case, as in most cases, as I said, it doesn't have any coercive powers. It can't enforce its interim measures. So it couldn't compel or force the surveyor to testify. And also, since the surveyor was not a party to the case, there was no inherent power from the tribunal, which it has towards the parties through its powers to, of course, decide the case. So if you are a party to the case, then you often respect the tribunal's interim measures because you don't want them to rule unfavorably. But with regard to third parties who aren't party to the case, this is obviously not the situation. So we had to turn to the courts, and we did that after obtaining permission from the tribunal to do this. And both the SEC rules, as well as Norwegian and Swedish arbitration acts, they allow parties, like I said, to seek assistance from the court to obtain evidence including witness testimony. But there are often practical challenges, as there were in this case. One initial challenge was that the third party was Norwegian, while the seat of arbitration was in Sweden. I know that Norway and Sweden get confused all the time, and people ask, is Norway the capital of Sweden, or the other way around? But Sweden is a neighboring, but still in a Scandinavian country, but it's still a different jurisdiction, different from Norway. And we could have approached the Norwegian courts, though I think that it would have been a bit of a slow process, since the testimony involved an arbitration in Sweden and not a case before the Norwegian courts. And in addition, we essentially wanted this surveyor to appear as a witness before the arbitral tribunal at the oral hearing in Stockholm. That's what we really wanted. And if we went to the Norwegian courts, we'd probably have to settle for a transcript of the surveyor's testimony, or we would have to drag the members of the tribunal from Stockholm over to Oslo to be present during the hearing in the Norwegian court. And all of this, I think, would in any event lead to delays. So we decided to cross off the Norwegian courts as the alternatives are on our list, and decided instead to submit an application to the Swedish courts to compel the witness to testify. And this was possible because there was a treaty between the Nordic countries which allows the courts in one of the countries to compel testimony from witnesses living in another Nordic country. And in this respect, we hired Swedish counsel to assist us and to draft the request to the Swedish court. And this is the point that I think is absolutely key. If you are operating in another jurisdiction than the one you are qualified in, or you don't know all the ins and outs of the legal culture in that country, then you need to seek advice from local counsel. Because one of the most important pieces of added value of the Swedish counsel was their knowledge of which court to approach. Because if you just read the act or the rules that you are complying with, it just says the courts. But oftentimes you have the choice of a number of different courts to which you can send your petition. And the local Swedish counsel that we engaged, they suggested that we not apply to the court, the district court in Stockholm, but to a smaller court outside the city. And the first reason for this was that there was to make sure that the application was dealt with fairly quickly. The court in Stockholm had a large backlog, meaning that our petition may not have been dealt with in time. The second reason for going to a court outside the capital was that the counsel that we had hired, they knew that the judges working at this other court had real knowledge and appreciation of international arbitration. So they understood what this was about. So they would understand, the nature and importance of the application. And this part of the advice turned out to be simply invaluable. Because the petition was handled by a very hands-on, no-nonsense judge. First of all, she was not deterred by the objections made by the surveyor's counsel. Like I said, he did in fact engage his own lawyer, and this lawyer wrote several letters to the judge in surprisingly bold form, with expressions and which I as a counsel would never have used. But the Swedish judge, she held firm, wrote several letters refusing this counsel argument, and actually ended up threatening the surveyor that she would fine him and that she would have him arrested the next time he went to Sweden if he didn't testify. So she was absolutely gloves off and dead serious. And all of this finally led to an agreement from the witness or the surveyor to testify on video, on a video screen, then in the Stockholm District Court. Because what also happened was that, like I said, we wanted, due to this surveyor's reluctance, we wanted him to testify under oath. So we didn't just want him to testify in front of the tribunal. We wanted to first swear the oath, which only the judge could make sure that he did, and then he would testify before the tribunal. So this judge, again, amazing. She arranged for us to have a hearing for one day in the courthouse in Stockholm, even though she was not a judge at that court, because she was a judge at one of the courts outside the capital. And then after placing the witness under oath, she let the tribunal members, the three of them, sit in the judges' chairs behind the bench. That's something they all, I could see on their faces, they all loved this. They felt very much in power, I think. And then after doing this, it was in effect like having a regular oral hearing before the arbitrary tribunal, except that it took place then in the Stockholm District Court. And the witness, like I said, testified under oath, which normally does not happen in arbitration proceedings. Now, having gone through all of this, I can tell you that there was a bit of suspense, to say the least, with regard to the testimony from the surveyor. Because given all the work that we had put in, it would definitely be very, very disappointing and quite detrimental to the case if the testimony wasn't favorable. But thankfully, the testimony went well, and at least as well as we had hoped, and we also went on to win the case. And let me just finish off by summing up, some lessons learned or some advice based on my experience in this case. First of all, you need to consider if assistance from the tribunal in the form of an interim measure is adequate, or if you need to involve the courts. In our case, it was obvious that you needed to involve the courts because the tribunal had no power over the surveyor. And in my experience, in most cases, you will come to the conclusion that you need assistance from the courts because the tribunals lack coercive power. I understand that there are some differences in other countries, but that's at least the situation in Norway, and I think also in most of Scandinavia. Second, if you are not qualified in the jurisdiction in which you are approaching the courts, definitely hire local counsel. That is like a rule without any exceptions. And third, consider along with local counsel how you can get hold of a judge that will really give attention to the matter, the attention that it deserves, and who understands the nature of international arbitration. I think in many courts, at least that's true in Norway, they have a very, very vague understanding of what international arbitration is. So make sure you can go to a judge who really understands what you're talking about. Because I am very sure that if we had not had our petition to get this witness or surveyor to testify in the hands of this very, very competent, hands-on judge, it wouldn't have gone anywhere near as well as it did. And I think that the overall message is that when you are asking for an interim measure, there are a number of practical aspects that you need to consider apart from the legal framework or the technical wording of the acts, because that only gets you so far. And in my experience, in this case and in others, that there are a number of additional practical things that you really need to think through in order for your interim measure to be successful. Thank you.
Thank you very much, Knut. That was an excellent insight into how it works in practice, at least in the Scandinavian region. I'm happy you found a judge with enough time to look at your case. I can say from my own jurisdiction, the backlog here in literally all city courts, as well as in the courts of appeal, are tremendous. We're looking at up to 2 years of waiting times from the finish of the written proceedings till you get a day in court. And that unfortunately also applies to most cases for interim injunction. So it's very, very challenging to find judges with enough time. Perhaps that would be a good question for the entire panel. How does it look in your respective jurisdictions? Perhaps starting with Harmut, Germany.
Not as bad as in Denmark. There is backlog, yes, because we had a lot of claims with regard to the automotive sector, because some of the car producers in Germany cheated, and so there are lots of cases against them, thousands of cases against them. But apart from this, it may also depend from the city. Yes, for example, Frankfurt is known to be overburdened. Stuttgart, I wouldn't say they are overburdened. You have to know where, but you don't always have the choice. So you were lucky, Knut, that you could choose. In many cases, you don't have the choice. So you have to take the court, the competent court. So that's it. And when going to the competent court, you may not know which judge is the competent judge for your case. But what, of course, you can do, you can call him, but I always do, I call the judge and trying to chat with him and convincing him it's really urgent, so what is possible? And that can work, If you have a reputation of being, let's say, serious, reliable lawyer, they might listen to you and they might be willing to believe you that's really urgent when you say, yes, it is. And of course, you have to deliver the proof, that's clear. But it can help to establish, let's say, oral relationship to the judge in place. So it's not too bad in Germany, I would say.
How about Italy, Patricia? Can you call the judge there and ask for special treatment or quick treatment?
Well, usually, as far as it concerns the interim measures with the state court, it is not so bad since you can go to talk to the judge and explain that there is the urgency. But apart from that, it depends also on the city. As Jakob mentioned, the small cities maybe are better. Also, I could say in Italy, if you go to Milan or to Rome or to the other big cities, it takes quite quite long. Of course, not so long because we are talking about interim measures, but in comparison, maybe with a small city where they are not so overburdened, the judges. But well, it's not so bad with the interim measures. I could say that that it's not so bad with the state court.
And Madrid, Carlos, how quick can you get your measure if you ask?
Well, it doesn't need to be Madrid. It depends on when you want to enforce the measure. So it could be Madrid, Barcelona, Bilbao, any town. It depends very much. Madrid is quite overloaded, so it's not the best place to ask for them. As regards to if you can address directly the judge, sometimes you can. Other times you need to go to a lower layer of officials, of civil servants in Kafkaesque structures where there are many layers and you have to move up to the top, to the judge. They will eventually listen to you. And the thing is that they are not very familiar with arbitrations. There are so many first instance judges, and they will get to know of this measures every now and then. I mean, it's not something that they will hear of every month or sometimes every year. So this can have a double effect. On one side, they will be ignorant. They won't know exactly what to do, and they will feel unsure, which is not very helpful for the party who is requesting the measures. But on the other side, they might find, and I find this experience interesting. It's something new. They want to know about it, and they will prioritize it. So I would think that less than 2 months is almost impossible. And from there on, I think more than 6 months would start to be a little bit exceptional. So between 2 to 6 months, maybe three months would be okay, but it's very difficult to specify more.
I see. And France, the situation there, Alexandre?
The situation in France as regards, if you want to have a judgment on the merits of the case, is rather long because the backlog is huge, especially in front of Paris courts. However, in urgent matters, we have a very fast track proceeding where you can ask the judge or a special authorization to bring the case in very urgent fast track. And you can have a decision in a very reasonable time frame of, say, 2 months maximum. And we have in front of the Commercial Court of Paris, we have a section which is specialized in international law and arbitration, which is rather new, but it has 5 years now. And the interesting thing in front of that court is that you are authorized to file documents and evidence in English if you want, without translation, and you can have witnesses that would testify in English. So that's very useful for international matters, and we have the same section, international section and arbitration section in front of the Court of Appeal of Paris. So my experience of the commercial court, the international section of the commercial court, is that judges tend to, especially in urgent matters, tend to know and to prepare the cases in advance of the hearing, and they usually know very well the intricacies of the case. So when you come to the court, you don't have to explain the matter from start, but they already know the case, they ask the right questions, and it goes very, very fast on that. So I would say it's quite efficient.
Knut, you have your hand up.
Yeah, I just wanted to add one thing to Helmut's comment that in Germany you have to the choice of courts is limited because you have to go to the court that has jurisdiction. And I just wanted to be a little bit more specific with regard to my case. In Norway, the situation is also the same. That normally, if you were asking for an injunction in a domestic Norwegian case, you would normally have to go to the court which would otherwise have jurisdiction if there wasn't an arbitration agreement. The special circumstance in my case was that we were essentially asking the courts in Sweden to have a Norwegian citizen testify, and that opened up the whole playing field for us to choose whichever Swedish court we wanted. And then I also agree with Carlos with regard to the communication with a court. I think can sometimes be a bit sticky. To use that expression, is you don't always just simply call a judge and ask him to handle your case. I mean, in Norway, it doesn't work that way either. But in this case, at least, there is a sort of a special court outside. It's not. I mean, it's not special in that respect. But the point is that the chief justice of this local court outside Stockholm used to be a Supreme Court judge, and he's very, very interested in international arbitration, and he had a very good relationship with one of the partners at the law firm that we had hired. So this laid the ground for some communication between them to make sure that our petition was heard. But I mean, in other cases, I also agree. There were definitely perhaps some hindrances in the way of having communication with a court or a judge.
Thanks for that. We have oh, sorry, Helmut, go ahead.
But just to add, Knut, some German judges don't like to be called. Others you can call without problems, so you may not know beforehand. So you have to be careful when doing that. It's not a general advice. It's not
exactly. Yeah, I agree.
But knowing the local judges, you may dare calling them, and then you open up the conversation, you may find out what works and what doesn't work. But some judges, also German judges, are very reluctant. Others like to be called because it can be, well, a nice change from just looking at your screen in your office. So it depends. It's not a general advice.
Thanks for that. So we have a number of questions from the floor. There's one here on what type of interim measures are there in the different jurisdictions. You've already touched on that, but perhaps which ones do you normally see in play? Is that freezing orders of assets, or is it securing evidence, or anyone really? Maybe
I can start by saying that in addition to the freezing orders you just mentioned, the securing of witness evidence, which I described through my story, also getting access to documentary evidence that you need as part of the arbitration case, and that can actually happen both after the arbitral tribunal is constituted. So there is an arbitral tribunal, but one of the parties is refusing to submit documents that one other party has required access to. But also before you initiate arbitration, if you have approached a party and you want access to documents in order to assess whether or not you have a valid claim, but you haven't yet taken the step to formalize and initiate an arbitration case, also in those cases, if there are exceptional circumstances, you can apply to the courts to order that the other party disclose the documents that you are requesting.
On freezing orders, I wonder in your respective jurisdictions, do you think that a lawyer would be at risk of attracting liability towards a client if the lawyer doesn't take steps in terms of at least addressing the possibility and discussing with the client the possibility of obtaining a freezing of assets pending outcome of the arbitration, especially, I suppose, in cases where the assets are no longer there when you win the case? What do you think? Do you have a view on that? Is there a malpractice risk there if you don't go after a freezing order? Perhaps, Alexandre?
Yeah, that's a very practical question. I think the duty of the lawyer is not only to have to get a good arbitration award that you will put on your wall, but of course to have an efficient arbitration award that you can enforce on assets. And then, of course, I think one of the duties of the lawyer is to help the client to identify assets from the beginning of the case and not at the end when you get the award. Obviously, that's a good point. If you identify assets, if you have good reasons to think that the defendant will not spontaneously pay or will not be able to pay or will not present sufficient assets for the enforcement of the award, then yes, I would answer that definitely you have to help the client to identify assets, and if possible, to obtain from the judge provisional seizures or freezing orders. That's part of the job, obviously, yes.
What do you think, Carlos? Is it possible to find out if the other side has any assets before you launch arbitration, or should you do it in case it is possible with measures from the court, for example, in your jurisdiction?
I have this exact case at hand in this very moment, so I'm thinking about it, because in this case it wasn't me who suggested it to the client, but the client who knows the circumstances of the counterparty much better, because there's even a familiar link between them, and we are discussing this. The thing is you need to transmit a risk of this assets disappearing in a matter of, I think we will have the sentence in a matter of weeks, and convincing, or maybe a couple of months at most, and you need to convince the judge. And in our case, requesting and obtaining this measure can take longer than the final sentence and the final judgment. and it can also create some confusion. So in this case, I think you should at least present this option to the client. He should make this decision. I would never risk not even putting this matter on the table. As far as malpractice, I don't know if a Spanish judge would consider it malpractice, because it's not a measure you would normally ask for. You normally assume that the losing party will have enough assets, and nobody would you expect the council to anticipate this outcome.
What about on the Italian law, Patricia? Do you need to pose a guarantee if you are seeking an asset freezing order? Does the requesting party have to guarantee the potential losses of the other side in case the order is successful, but the outcome of the case is not successful for the requesting party?
Yes, the party could ask for this kind of guarantee. And talking about the freezing orders, as we mentioned, one thing that we have in Italy is that we have two types of seizures, which I do not know if you have in the other jurisdiction is differences. We have the sequestro giudiziario and the sequestro conservativo. It means that first is a provisional measure whose purpose is to ensure that certain assets are preserved and made unavailable to the parties until the dispute has been settled. And the other one is a measure that aims at preserving the creditor's asset security, anticipating the effect of the seizure. So this is, I think, one of the differences that we have from other jurisdictions.
And what I wonder in, for example, in Norway and Germany, what is the typical size of the guarantee, and what form of guarantee is typically requested or required if you're seeking an injunction or a freezing order? Perhaps Harmut first for Germany.
Okay, well, first of all, also German courts may, of course, ask for security, or the opposing party may ask for security, and the court will decide, yes, please bring the security. The amount will depend on what you are asking for. So if you're asking for, let's say, 1 million, and the security might also be 1 million plus eventual costs, so it will be even more than what you're asking for. In most cases, it will be a performance bond by a bank.
And in Norway, is that the same, Knut?
Again, very similar to Germany. So the wording is that it's adequate security, which I guess is often a point of discussion because perhaps the respondent or defendant is exaggerating the loss that they will potentially incur if the freezing order or other form of interim measure is ordered by a court. So I think that it's difficult to be specific with regard to exactly the amount of security. When it comes to the form of security, all options are essentially open. But in my experience, it's a bank guarantee is the normal way of providing the required security.
There's another question from the audience on how interim measures are typically, or with what measures, so to speak, an interim measure can be enforced by the national courts. Perhaps do a round of the table again, starting with Alexandre for French law. Do you have, is there a penalty type measure you can, as a judge, impose, or how does it work?
As I said on my presentation, we have a specific article in French law, which is Article 1468, which says, of the procedural code, which says that the arbitrators have the power to render interim measures, and they can order penalties to enforce those interim measures. The point here is that once the arbitrator has rendered an interim injunction, this injunction needs to be enforced by the judge. So basically, you have two steps. The award is not enforceable by itself, and therefore you will have this enforcement step before the court, where it can go easily because it can be easy because the first phase goes quite fast. You basically have to seek an order from the first instance judge, and this order is ex parte, so you don't need to have a contradictory debate. But once the judge has rendered the enforcement order of the award or the interim injunction, then the defendant can appeal that enforcement order from the judge, and the contradictory phase can last sometimes a few months. So it's not that easy to obtain. The point, however, is that the first instance order of the judge is enforceable notwithstanding the appeal. So that means that once the order has been rendered, it can be enforced, for instance, on assets. If the defendant does not comply with the order, the penalty can be enforced, notwithstanding the appeal. So there are ways to suspend the enforcement and the applicability of the order. So you can suspend that, but it's not that easy.
Very good. Thanks for that. And under Spanish law, is that the same, Carlos?
What I just heard from France is very similar to Spain. I can't see any relevant difference that I would like to pick up.
And Italy, is that the same?
Also very similar to France and Spain.
And perhaps Germany, some differences there pointing to? Or?
Well, not a difference, but there's one aspect you should know in Germany. If the interim measure turns out to be unfounded in the end, then the party who has asked for it is under an obligation to compensate the other party for damages. And that's a risk. You should know. So once again, it's an argument for making sure that you have a strong case.
Yes.
Before asking for interim measures.
And I suppose it's also the double-edged sword of the interim measure, but it's also what gives it so much power. If you actually obtain it, I know a lot of sides will say you have won the case because the judge has found that there's a good plausible case at hand, and also likely that the other side is doing something which is not right in terms of trying to conceal assets or remove assets. That's at least the case under Danish law if you look at freezing of assets orders. So, but on the other side, if you fail in the following proceedings where you have to justify and prove that you have the right to obtain the measure, you're looking at a hefty liability. So yes, perhaps Knut and then Carlos, for Norwegian law, is there a different view there?
I think that if I remember, your question went to the enforcement of the interim measures, and in Norway there's a I guess a clear separation between the interim measures ordered by the tribunal and those ordered by the court. So there's no overlap in the sense that you can't take steps to enforce an interim measure which has been ordered by a tribunal. You would have to, apply separately to the court for interim measures, and I guess that the court would consider the fact that the tribunal has ordered interim measures, but it's not really a question of technically, at least, enforcing the tribunal's measures. It's the court's own assessment, the court's own measures. With regard to the question of liability, it's the same in Norway as under German law. So if you obtain an interim measure and it turns out in the end that you didn't have a valid claim towards the respondent after all, then you are liable. It's a strict liability. There's no question of whether or not you had reason to believe that you had grounds for a case. You are strictly liable for their financial loss.
Carlos, you had your hand up?
Yeah, very, very, very quickly. One reason why I said previously that one should be cautious and only ask for interim measures only our strong case is the confirmation bias, because the judge and the arbitrator will, this is a bias we all have, we can all fight against it, but it's there, the risks exist. And there's a risk that the judge or the arbitrator, once it has ruled in an interim context, in a sense, for him or for her, it will be difficult at a later stage to say, oh, I was wrong, I shouldn't have granted it, because if you lift those measures, it in a sense, it means you weren't right. Well, it doesn't need to be, because under those circumstances and with that knowledge, maybe it was a perfect decision, with a better and deeper understanding of the case, it's a different opposite decision. But I think this confirmation bias will always be there. And if the judge ruled in a sense, he will have this picture that one of the parties is right, and this might, it shouldn't, but it might impact his or her final decision.
Patricia?
Just wanted to highlight something that is similar to what was mentioned by Harmut about Germany, that the interim measures issued by arbitrators cannot be enforced but the same without the intervention of the ordinary court. So this is because the arbitrators are absent of coercive powers to enforce their decisions. So this was a similarity that I would like to highlight with Germany.
Which I suppose makes it so attractive to go to the ordinary courts. But at the same time, you have to wait, typically.
Yeah.
That brings us to the end of the webinar. I know there are many more questions from the floor, and we could go on, but I know we all have a busy schedule. So with that, thank you very much to our speakers, Patricia and Knut and Harmut, Alexandre and Carlos, for a very interesting panel debate. It's been a pleasure moderating this, and I hope to see you all soon somewhere. So thank you very much, and have a great day.
Okay.
Thank you.
Thank you very much.
Thank you.
Thank you.
Thank you.
Bye-bye.
Great talking
Thank
to
you.
you. Bye-bye.
Bye-bye.